cases in Freehold, right? Hello, Lee.
Hi, Richard.
Can you see me and can you hear me?
Both.
Great, wonderful. I have you here at the Lomurro Law Firm in Freehold, New Jersey. There are a couple people who are listening. Everybody, welcome F. Lee Bailey. You didn't expect a round of applause, did you?
Well, I would hope for one, of course.
Just a real quick introduction. Everybody probably remembers where they were on October 3rd, 1995. And they probably remember this picture, which is of O.J. Simpson reacting to the not guilty verdict. On his left-hand side was Johnny Cochran. On his right-hand side was F. Lee Bailey. Lee, what did it feel like to be in the center of the world, not just in the legal world, but in the world in general on that time back in 1993?
That was 95.
95.
Yeah. I was glad for the result. It was not a pleasant experience.
We're going to get into that a little later. I know that you look at it a little differently now probably than when it was occurring. So that look on OJ's face and on Johnny Cochran's face and your face, is it a little manufactured? Because by then he had already heard from a couple of the guards that it was likely he'd be not guilty. You told him yourself that you felt you had an acquittal. Was the feeling manufactured at all, or was it still a genuine and true feeling?
No, it wasn't manufactured. If you look at my face, it's kind of a Cheshire cat smile. There's no surprise there. I knew what was in the envelope. I went to tell OJ what was in the envelope, and he'd already been asked for his autograph by a bunch of guards who said they wouldn't see him again, which is a bit of a hint. Johnny Cochran, I had assured we had an acquittal in the envelope. He never quite signed on until he heard the words. And if you look at him in this picture, you can see that he is less than confident. He's a little bit in awe there. And in the back, you see Bob Shapiro rushing out of the room to trash his client and his colleagues.
All right, we're going to get back to OJ a little later in the show, Lee, but you're back in Freehold, New Jersey. It's probably been 50 years since you've been here. I was talking with my dad, who's a lawyer at the firm with me here, and he said, you know, Rich, Lee tried a case in Freehold, New Jersey 50 years ago, a murder trial. And I was like, okay, Dad, sure he did. Yeah, okay. F. Lee Bailey tried a case in Freehold, New Jersey. But sure enough, I went and did my research, and you did. You tried an absolutely bizarre case with a guy named Dr. Carl Coppolino. It was a murder trial. Can you tell us a little bit about that case?
Yes, Carl Coppolino was an anesthesiologist. He had been having a bit of an affair with an older woman named Marjorie Farber. Her husband was a retired colonel, Army colonel, and one day he died. Much later, Marjorie Farber, who found out that Coppolino, number one, had moved to Florida, number two, had a new girlfriend, told the police that Coppolino had injected her husband with a chemical that made him die. And based on that, and no corroborating evidence, they dug the body up. The autopsy didn't help them at all, indeed to the contrary. But they thought they had enough to go to trial because he was simultaneously indicted in Sarasota, Florida, for the death of his wife. And they figured, you know, the jury will know lightning doesn't strike twice. And it was indeed an impossible atmosphere in which to pick a jury that did not know about the Florida indictment. Indeed, it was impossible.
Well, let's talk about that, actually. Jury selection. So it's a little bit of a package deal, you think, because everybody was aware of both cases. 2 murders. What are the odds that you're going to be able to beat a murder twice? But for jury selection, you also had to deal with the issue of this being a well-known fact that he had an affair with this woman. Adultery was part of the case. How did you address that with jury selection?
Oh, I had a little fun with that. And this, by the way, was only the second jury I had ever selected. The first was a month before in Cleveland for Dr. Sam Shepard, because in Massachusetts, you don't select juries until they changed the law 3 years ago. So I was cutting my teeth, finding my way, but I did happen on a German engineer whom I liked immediately. And engineers are usually taboo on juries. They're too straight-laced. But I said to this fellow, are you going to be so prejudiced by the evidence, and there will be evidence, that Dr. Coppolino was fooling around with someone not his wife, that you would be prejudiced against him? He said, oh, no, not at all. I fool around myself sometimes. And when everybody laughed, as your group just did, he pointed his finger at me. He said, I bet you do, too. And I took the bit.
And what did F. Lee Bailey do?
Well, I kept him on the jury. He became the foreman of the jury. And when the evidence was concluded and the arguments were made and the jury charged, he went in the jury room, sat in a corner, and began to read a little German paperback. And he informed everybody that he was satisfied that Coppolino was not guilty, and as soon as they agreed with him, they should come and tell him. And as soon as it became unanimous, that would be the end of the case. And sure enough, it was a short deliberation.
So why wouldn't the prosecutor have struck that juror?
You'll have to ask that from the ghost of Vincent Cooper. Because then, I guess in his mid-60s, Vince was a nice but very straight-laced man. And I don't know why he didn't take him off. Maybe he bought into the notion that engineers are good for the prosecution, because that is generally bandied about. I've never seen any evidence that there's any truth to it.
Could be. Actually, I'm going to ask you about another thing. As far as I know, he did not object to, which is your opening statement. Now, you wrote about your opening statement in your book, The Defense Never Rests,
Yes.
which is, I would highly recommend any trial lawyer read this book. I had a great time reading it, and I think it's stood the test of time. But in the book, this was your opening statement. This woman drips with venom on the inside, and I hope before we are through, you will see it drip on the outside. She wants this man so badly that she would sit on his lap in the electric chair while someone pulled the switch, just to make sure he dies. This is not a murder case at all. This is monumental and shameful proof that hell hath no fury like a woman scorned. Wow. How did you come up with that, and how was the prosecutor not jumping on top of counsel table, screaming objection, argumentative, facts not in evidence, and everything else?
Two reasons. Number one, I think Vin Cooper was a little fascinated, and I do believe at beginning a story with a strong narrative hook. And that you could call a narrative hook to get
I
your
would definitely call that a narrative hook, yes.
And the other reason was that Judge Elvin Simmel, who presided, one of the best judges I have ever bumped into, gave me all the help he could in keeping prejudice out of the jury box. And he had said he was going to give me some latitude to try and fight that, because he said we could move this case to Timbuktu, and everybody would know about the two indictments. So have at it. If you get a conviction, you probably get it reversed. And so Cooper, I think, gave me a little leeway too, so that he would not compound the problem, because he certainly had the edge going in.
So you got an inch from the judge and you took a mile.
I got a foot from the judge and I took 12 inches.
Well played. So I actually, you said you like to have a hook and a narrative in your opening statement. Do you build from a theme when you try cases, or was this something that you kind of came up with and said this one's going to work? Do you write it out? How do you go about getting that opening ready?
Well, and many times I don't give it until the prosecution has rested.
Wow.
Because it can be, as the second Coppolino trial proved, it can be very dangerous to make a commitment to a jury and then be unable to keep it. And in the second trial, I told them that he was an excellent witness, which he had been in New Jersey, that he would testify and explain that the puncture in his wife's thigh wasn't a deadly drug at all. She took vitamin B shots, and she had died of a heart attack. Then he decided not to testify, and it threw that strategy into a cocked hat and probably contributed heavily to his conviction. But if you have a strong case and you can afford to lay it all out before the prosecution calls its first witness, I like to do that, and I like to do it in a way that the jury is much more interested in what I've had to say than they were in what the prosecutor had to say, because prosecution opening statements sometimes contain some rhetoric. They're not supposed to, but I was given latitude in the Freehold case to dash the statement up with a bit of rhetoric.
Sure. So the theme kind of came across in your opening and throughout the trial that this was really about a jealous and spiteful mistress as opposed to a murder. Now, one of the ways that you played on that was this: the mistress, the Marjorie Farber. She suggested that she was hypnotized by Dr. Coppolino, which sounds ridiculous. But at that time, Coppolino had written a book on hypnotism, and it seemed to be one of the leading authorities on hypnotism in the United States. So how believable was her position that he actually had a spell over her and that she was under his spell, as opposed to just being someone who was trying to make up a way to excuse herself for her behavior?
She thought that up. You can't hypnotize a person into acquiescing in death. It just doesn't work, particularly if the death is murder. She had been treated by him under hypnosis to quit smoking, and that technique was very much in vogue at the time. Coppolino was not an expert in hypnosis by a long shot. However, he was a good friend of Dr. William Joseph Bryan, who was indeed head of the American Institute of Hypnosis, where I was teaching, and it was Bryan who said, "Would you please take on this impossible case in New Jersey and Florida for my friend Dr. Coppolino?" And that's how I happened to take it on.
How did you deal with cross-examination of Mrs. Farber?
I would say it was stunning for this reason. I happen to have a howitzer in my pocket, and at 4:15 on a Friday afternoon, when you really want to leave the jury with something to chew on and digest over the weekend, is an excellent time to bring out your sledgehammer. After she testified that her husband was having a heart attack and Dr. Coppolino wouldn't do anything about it, I produced a document. I said, "Is that your signature?" And all I showed her was the signature. And she looked at it. She remembered. She was stunned. And she said yes, because she had to. I opened up the paper. I said, "Read it and weep." The contents of the paper were, "Dr. Coppolino believes my husband has had a heart attack and recommends that I have an ambulance take him to the hospital, and I decline."
So a medical release she signed.
Well, it was no more than that. It was an acknowledgement of the fact that her husband, who did die from a heart attack, was in trouble, and that she wanted him dead so she could more frequently ball around with the good doctor.
So there was a full book written on the Freehold trial, and that book, No Deadly Drug by John McDonald. By the way, I had to get these through the internet. I can't find these books anywhere else, including your book. I thought it would still be published. It's not. It was supposed
they're all on Amazon.
I got them on Amazon. It said very good condition. This is what I got it in. So
nobody will stock those anymore because Amazon is such a handy source.
Yeah, well, they had plenty of copies available. I ordered a couple, and none of them came in great condition, but they are available. So anyway, this author wrote about your cross-examination of Marjorie Farber, described Bailey's saturnine ability to select exactly the right words to make testimony sound ludicrous and insane. Is that how you would describe how you made Mrs. Farber look?
I don't know, because I didn't ask the jury that, but I sure was trying to.
Well,
and I should
you got your message across.
A footnote, because I hold Freehold dear in my heart. I had a good experience there. I stayed, I think, at the American Hotel.
Yes, you did.
The press was there in droves, really good reporters, like we don't see anymore, now that Linda Deutsch retired after the Simpson case. And during the trial, a fellow came up to me, I think he was a lawyer, and he said, "My son is editor of the local high school paper, and it would really be a coup if he could interview you. He's 16. So I said, fine, I've got a commitment in the city over the weekend, but he wants to come in Saturday afternoon. I'm being interviewed at 10 o'clock. I think I should be through by 4. And so he came on in, and as he walked in, the main writer of the Playboy interview, Nat Hentoff, walked out of my suite. And this young 16-year-old was aghast. He said, was that really Nat Hentoff, who was a very famous guy at that point? And I said it was. And then he conducted his interview, and his name was Barry Scheck.
Oh, wow. That's a great story, Lee. Thank you. Look at that. Well, back to the Coppolino trial, taking the stand. The doctor decided in the Freehold trial to take the stand. He did not take the stand in his Florida trial. The Freehold trial was a not guilty. The Florida trial was a guilty. Why did he decide to take the stand in Freehold? Why didn't he take it in Florida?
Florida, he listened to someone else who said, you've got the case won, because I had in fact called the experts lab chief back in and gotten him to admit that his test did not prove the presence of the drug. That should have been a directed verdict, but no elected judge was going to give Coppolino a directed verdict for anything, including playing patty cake. However, there just wasn't any evidence to show that she had ingested succinylcholine chloride, which for your viewers is a synthetic form of curare, a very deadly drug used to put on the tips of arrows by some aborigines in South America. And it will kill you very quickly. It simply paralyzes your muscles. So I say very quickly, an exaggeration. It just disables your ability to breathe. And so you sit there and suffocate with your eyes wide open, all your senses working, a nasty substance. Coppolino's friends, who knew more law than I did, told him, don't testify, because sometimes if you do that, you will be told later on, well, there wasn't enough evidence against you. Once the jury saw and heard your testimony, that was enough evidence. And that has in fact happened. So he decided to overrule me. And I said, you're really playing with fire, because I told the jury that you were going to testify. And now they're going to think he must have confessed to his lawyer he did it, and the lawyer can't put him on the stand. And I think that scotched it. The verdict should have been thrown out had a member of the clergy not induced him to fire me and drop his appeal to the U.S. Supreme Court. There was a case right on point that said arson murder has to be first degree. Anything less than that is an acquittal. It won't fit lack of premeditation. Coppolino is the only man in the history of the United States I know of who was convicted of second-degree murder for poisoning. It simply can't be done.
Because it requires premeditation. Has to.
Well, it does, because most chemicals, particularly if induced by a doctor, can be reversed. So you not only have to have an intent to kill, but you have to have an intent to make sure you've killed. Right. And that's really not an easy burden to beat when you're talking with poison. However, I must tell you, I was getting a little more sophisticated in jury selection then. First trial was November of 66, the second in May of 67, and on came a lady who had brought her suitcase to the courtroom. Anybody who brings their suitcase wants to be on the jury. When it's made known to them, they're going to be locked up. And the odds are 9-1 you don't want him or her on the jury. That kind of enthusiasm, not so good. She went on to announce that she was Mrs. Waples from Naples, which is where the case was tried, and that her husband had been a very smart lawyer, and that she had guided him throughout his practice, even though she wasn't the lawyer, and that she knew a lot about the law and could be helpful to the jury. Well, now we have a triple threat here.
Right.
And I said, are you really Mrs. Waples from Naples? She said, I have. I said, well, meet Coppolino from Portofino, and you're out of here.
That's great. So in the Freehold trial, and Freehold holds you dear to our heart as well, Lee. In the Freehold trial, you got a not guilty verdict, and it's memorialized in that book I was quoting from before that everybody went back to the American Hotel where there was a party, essentially. The bar was packed, and there was no greater crowd than around you where people were passing you menus, napkins, and even dollar bills for your autograph. Yeah. Now, that sounds pretty larger than life after a not guilty verdict. What was it like to have that type of environment over at the American Hotel?
Well, it was wonderful. I mean, they were great people. They were very kind to me. Bear in mind, this came down 3 weeks after Dr. Sam Sheppard was acquitted in Cleveland.
Your stock was very high at that point.
So I recall very well one of the best reporters there, his name was Theo Wilson from the Daily News, said, 2 in a row, lightning doesn't strike twice, which I had been talking about in jury selection. I think I'll keep an eye on you, she said, which coming from Theo Wilson was high praise.
And how old were you at that time, Lee?
I was in 1966, 33.
33 years old, back-to-back, enormous national acclaim cases.
But I've been trying cases, first-degree murder cases, for 6 years.
Let's talk about the Sam Sheppard case. That's actually a good time to transition. For those of you who don't know, the Sam Sheppard case was the inspiration for both the TV show and the movie The Fugitive. Tell us about the Sam Sheppard case.
Dr. Sam Sheppard was accused of killing his wife on July 4th, 1954, by, I've got to say, a crooked newspaper publisher who insisted that Shepard be arrested and tried. And I'm not speculating because he wrote a book boasting about it, which nobody would publish, so he paid to have it published. But Cleveland was a tough place to be in 1954. It was referred to then about the opposite of what it is now, the biggest hick town in the country. And they were set in their ways. Indeed, a police lieutenant said to me when I first took the case as a brand new lawyer, I was 1 year by the bar, he said, well, why are you trying so hard in this case? Everybody knows you can't win it. I said, because I'm satisfied the guy didn't do it. Always said, if Sam Sheppard is innocent, I don't want to know it. And that was the attitude they were up against. He got tried by a pack of wolves. Essentially, he was convicted of second-degree murder where the victim had been struck 35 different times in the head with a blunt instrument. No room for second there. But that's what juries do when they're not sure. They think that's a compromise and, he'll get a spanking and they'll let him out. Shepard was convicted. He lost 11 appeals. He hired me. I lost another one. I'd only been hired to give him a lie detector test. When I lost that appeal and the lieutenant told me he didn't want to know if Shepard was innocent, and I went to the publisher who was the culprit, Louis B. Seltzer of Scripps Howard, and had a good solid confrontation with him, which ended with me promising to not only bury him, because I have a 30-something year age difference, but also to pee on his grave, which I've not got around to yet. But
which he and his boys deny that encounter, right?
They don't. I don't know that they deny it. I don't know if they're ever given the opportunity. But I can tell you what happened. And if there were doubt, of course, they could take a polygraph test if they're still alive. I don't think any of them are still alive. They were all much older than me. Seltzer, I think, was 68. And I was 28.
So the Cleveland press, by the time you get into the case, you have to take this all the way to the Supreme Court to get him another trial. And the Supreme Court, you can tell us about oral argument in front of the Supreme Court, but one of the bases for your argument was that the press had interfered in a fair trial because of how much they had pretty much projected his guilt into the newspapers in Cleveland. Tell us about the Supreme Court argument.
Well, first I want to correct that because the appeal resulted from a district judge in Dayton issuing a writ of habeas corpus saying that I have found 5 independent constitutional violations, and there are more in the record I need not search out. But this trial was not only unfair, it was a mockery of justice. Now, there are strong feelings, and Ohio was not the most sophisticated avant-garde state in the world, and the Ohioans buckled up on both sides. It got overturned 2-1 on appeal, and from that I went to the Supreme Court. And they did not rule that the flaw was the press. They ruled the flaw was the trial judge, which I had argued, because he did nothing to protect Sam Shepard from the press. Indeed, he gas on the flames. He was running for re-election during the trial. The prosecutor's name was on the ballot for judge during the trial, and they milked this case for all that they could. If the press wanted something, they had only to ask.
When you got to the Supreme Court, now you've argued in your career in front of juries, in front of judges at all levels. The Supreme Court, you've said, lived up to the hype. It was as amazing an experience as you had hoped for. What was it like?
I think I had, and for a so-called tough Marine jet fighter pilot X, I didn't have it off it, but I think I had a bit of awe as I watched the justices function. There were no women on the jury at that time. Indeed, that was thought to be sacrilegious in some form back in 1966, although Sandra Day O'Connor was coming. Nobody knew it. But they were a mixed bag of generally great intellect, balanced off by people who had street sense, feelings, and other good qualities. And I thoroughly enjoyed it because, number one, I enjoyed watching William Saxby, the Attorney General of Ohio, who at the last minute decided to substitute himself for the counsel who knew the case and got in trouble immediately. And they simply took him apart, as these guys often do, and I'm talking about the small men on the court, Frankfurter and Black in those days, both just barely 5 feet. Frankfurter, a Harvard professor, he had represented Sacco and Vanzetti, who were executed en masse for a crime which at least one of them was no doubt innocent, and then been put on the bench, I think by Roosevelt. And Hugo Black had been a member of the Ku Klux Klan, who declared himself reformed and was put on the bench, and they were dangerous. You could not see them unless you had evoked their interest, because they're so short. They had to lean forward from their seats. But when they did, you better watch your ass. Were wasted. And Bill Saxby decided to start off with a narrative hook. He said in his inimitable Ohio twang, "Your Honors, this is just like a case from Mr. Bailey's home state where a bunch of bleeding hearts kept the case alive long after it should have died." And Frankfurter leaned forward and he glared and he said, "Mr. Saxby, are we going to have to decide that case to reach this one?" And Bill wilted. He didn't say another helpful thing for the entire argument.
Well, keep it alive, you certainly did. The Supreme Court ruled in your favor. You were able to go back and have another trial for Dr. Shepard. Tell us about that case when you finally and ultimately got him to be declared not guilty.
I thought I was going to have trouble picking a jury because everybody in Cleveland was divided. It was the first jury I ever picked in October of 1966. I had a large Polish gentleman, fairly typical of the Cleveland population and the salt of the earth, who admitted he had an opinion about the Shepard case based on all that he'd read and heard. And I asked him what the opinion was. We were in a closed room with no other jurors present. The judge said, "You can't ask that." So I said, "Okay, take him off." he waited outside the courtroom door for me. And at the first recess, he came up to me very miffed, and he said, "How come you strike me from the jury?" And I said, "Because I didn't know what your opinion was, and I was afraid of it." He said, "I was trying to tell you, I know he didn't do it." Not very astute jury picking, but you roll your dice. The high point of that case had been laid in stone before I ever get close to it. There was another little man, like Louis Seltzer, 5 feet tall, Napoleonic complex. His name was Samuel Gerber. He was the county the county coroner who had jumped in early and made himself into quite a public figure. And he had testified in the first trial that where Marilyn's head was found on a pillow soaked in blood, he had seen the imprint of a surgical instrument. That was pretty damning to an orthopedic surgeon, because not too many people bludgeon others to death with a surgical instrument. His lawyer, who was a labor lawyer and not a very experienced defense lawyer, did not dare ask, "What was it?" for fear that he'd get an answer. And Gerber, during the 12 years between trials, lectured all around the world about how he had won the Sheppard case with the surgical instrument testimony. So when he got on the stand this time, he was all but quaking, because he knew what was coming. And I just put on my best Cheshire cat smile and said to Dr. Gerber, "I want to read something out of your testimony in 1954. And now, as we all hang at the edge of the cliff, Doctor, what is the name of that instrument?" He said, "I don't know." I said, "Where have you looked?" He said, "All over the world." End of case, right there. I mean, the jury was in stitches. The press took him apart, and I don't have to pee on his grave. He died being vilified for being stupid.
You also, in reviewing the case, it seemed to me like you had a To Kill a Mockingbird moment where one of your medical experts was able to determine that the killer had in fact inflicted the wounds with his left hand and your client was right-handed. Was that an important part of the case?
It was, because the suspect that I described to the jury as the most likely to have been the killer, she was the wife of the mayor, who was indeed having an affair with Marilyn Sheppard, and used to go up and jolly her a bit. When a certain light went on in the house, that meant Sam was out on emergency call down at the hospital. Only this time the light was on by mistake. Sam was asleep on the couch under the stairs, where he wouldn't have been seen unless you looked around. So we're pretty sure that's how it all happened.
So
the who described, by the way, was not a medical person. Dr. Paul Leland Kirk was the Henry Lee of that era. He was the criminologist in the U.S. The prosecution and the court would not allow the Sheppard defense team into the house until the trial was over. They could do no investigation. Their experts weren't allowed to sample anything. And so then they brought Dr. Kirk in, and he pretty much showed that there was blood there that didn't come from Sam or Marilyn, that the blows, none of which was fatal, were struck by someone who wasn't very strong, i.e. a young boy or a woman, and that the killer was left-handed from the spray from the weapon, which is fairly common criminological technique. He was a backbreaker to the prosecution's case had we not had Gerber dancing at the end of a string.
So Dr. Sam Sheppard was found not guilty. Your career catapulted after that. His return to society was not so successful, I'll say. What were the difference between his life after the trial as opposed to your life after the trial?
Well, that did not really do the catapult. Catapult had happened before, when I had the Sheppard case, the Strangler case, and the biggest mail robbery in the history of the United States, all running together. So one or the other was going to put me in front of the camera and in the printed media on a chronic basis, even though it was 3 different cases, and of course each one would mention the other 2.
Right.
But when Shepard and Coppolino got acquitted within 30 days of one another, then I would say, as Theo Wilson said, gonna keep an eye on you. And indeed, they began to show up with money, because Shepard and Coppolino didn't have any money of substance.
Now, you actually you ended up on the cover of both Newsweek and Time magazine. Pretty remarkable stuff for a lawyer. Bruce Springsteen did it. He's another guy from Freehold, but I can't think of too many other people that are on the cover of Newsweek and Time magazine. What was it like to have that type of exposure?
Oddly enough, I got those 2 covers in cases that I lost, at least in the view of the public. The first one followed hard on the heels of the Coppolino case in Florida. And by the way, the book you held up, No Deadly Drug, by John D. MacDonald, he was my hero. All I ever wanted to be was a novelist like he was, and he was a good friend of mine. And he came and after the trial at Freehold, which he attended, Florida, he didn't bother. He said, this is a dirty business. You have to go suck up to both sides to get any information. John was a wonderful guy. The other was the Hearst case. The Hearst case I won, but nobody knew it at the time because they didn't know what I was hired for. She was a very strong suspect, and properly so. I can tell you only because she wrote a book about it.
This is Patty Hearst.
Yes, a very strong suspect in a brutal murder during a bank robbery. A pregnant woman was shot in the belly, killing herself and her fetus with a double-barreled sawed-off 12-gauge shotgun. And when she arrived at the hospital for a determination she was in fact dead, or DOA, the emergency room doctor who lifted the sheet found himself looking into the face of his wife. And that's the case I was hired to keep her out of, and we did. The other 20-odd cases, we knew she was going to take a fall somewhere. She did. I think she should have been acquitted, but not many people are as hip or were as hip to brainwashing as I was then, because as a military pilot, we had to know about it.
All right, Lee, we're going to take a change of gears here, and we're going to go to the O.J. case. You have been described as O.J.'s last defender. And that is because still to today, you maintain his innocence. You write a very extensive and thorough explanation of this on your website. As you sit here today, you believe O.J.'s not guilty.
Satisfied that he could not have committed the crime, and therefore the civil verdict has to be wrong. There just was not an opportunity. He had one of the strongest alibis I've ever encountered. And I must tell you, defending people and giving it your all is one thing. But to run around after the trial, after they get acquitted, and vouch personally for their innocence when you know it's not true is quite another. And I would never do it. Now, I am known as the last pure defender who hasn't equivocated, and those that have done so for personal reasons, not because their beliefs changed. But there are 2 other staunch defenders. One is the chief investigator, and the other is the only lawyer who sat through both trials. And the 3 of us are writing a book, which, when you get a copy, Richard, will be the Bible on the Simpson case.
I hope it'll be autographed, Lee.
Oh, vociferously.
So, if O.J. didn't do it, you've been pretty clear that you believe who did do it. Tell us who committed that murder.
The FBI published a memo, which I saw. It was about 3 weeks after the killing, and it suggested that she had been the victim of a Colombian necklace, which is a huge slashing of the throat. Her head was taken almost clean off because she was mistaken for a gal who had been living with her until the day before the murders, who owed the Colombians $30,000 for cocaine. Drug dealers, of course, can't bring a lawsuit. And so they try to set up examples of what happens when you don't pay. Now, she was seen by a witness who has never been called yet, but is so wonderfully documented, no one will contest him. He'll be in the book. His name was Tom Lang. He saw Nicole with the people who probably killed her and was so upset by what he saw, he took his dog and walked in the opposite direction and then realized the next day what he had seen. But I think it was a drug debt. I think a couple of real stupido animals were sent out to do her in. They did, and when they got back to camp, it was discovered they had blundered, killed not the right person, but the ex-wife of one of the best known people and at that time best liked in America, and were executed on the spot for their mistake. That was the FBI's information. I think it's probably true.
Interesting. Wow, Lee. How were you brought into the OJ case? At that point, you were already famous. You'd done probably hundreds of cases. Who brought you in? Why did you come in? And why did you stay in, more importantly?
Three good questions, three different answers.
Thank you, Lee.
I had, if you're not already a great lawyer, you're pointed in that direction. I had been friends for some years, not very close, but friendly, with a lawyer named Bob Shapiro. And a month before the OJ case, he had sent me a rather large case to handle, which turned out to be a tragedy, but at the time, it looked pretty good. Bob called me in the middle of a polygraph test on OJ, which he shouldn't have run. If he'd called me beforehand, he would never have run it. You cannot test what we call an uxoricide, and that's killing your wife or husband or someone that close to you within probably 2 weeks. Your system just isn't settled down enough to make polygraph tests work. And the test was bananas. I spoke to the examiner, who's a good friend of mine. I know most of them in those days in the country. I said, Dennis, what the hell are you doing running this guy 3 days after? Right. He said, Shapiro came in and insisted on him. I told him it shouldn't be done, but he said they're going to arrest him tomorrow, and he didn't want to run him in the jail, so I agreed. And we're not getting a result here. That's how I got in the case. The next day, of course, was the biggest oxymoron in the history of the English language, the low-speed chase. It was not a chase, it was an escort, because A.J. Cowlings was driving the Juice's Bronco, and he said if you come any closer, he's going to kill himself. So they all just kind of hovered offshore, as we say in the helicopter world. And that turned the country against him. I think after that, we had an uphill battle.
Sure.
Next thing I know is Shapiro says, they got him cold. He's got blood all over his house. It's in every drain and so forth. So I'm out trying to recruit a couple of psychiatrists who would say he lost his mind. When Shapiro calls me again and says, I have bad information. They got nothing on it. Well, he then asked, would I committed the case? And then he asked, would I be the architect of the preparation and when the preliminary hearing was over? And I said to him, oh, Jerry Ullman blew it. You could have taken this guy Furman apart. He's a Nazi. He's a bigot. You just let him slide away. He said, well, I'm hiring you to cross-examine Furman. A couple days later, Alan Dershowitz, who's a very good friend of mine, and I are on TV talking about the OJ case. Dershowitz says, Shapiro better make up his mind. You can't be not guilty and insane at the same time. So we hired Alan Dershowitz. And that kind of quelled that bit of criticism. Alan, of course, one of the best appellate lawyers alive then and now. But it gradually growed. Now, unbeknownst to me, Shapiro signed an agreement with O.J. Simpson. And it said, for $1 million, I will defend you and include the services of F. Lee Bailey.
Volunteering you.
He did not show me a copy of that agreement, but on his letterhead, on the upper right, it says of counsel. And I want you to alert all your fellow would-be great lawyers that if you allow your name to go of counsel, you have the liability of a partner. So I was in, whether I liked it or not, when I called Bob and said, how did you happen to sign me up without talking to me? He said, oh, you're a volunteer.
And that was the end of your relationship?
No, but it didn't get any better after that. I no longer was a terribly trusting friend. I said, well, I assume you were going to at least split it. He said, no, I sent you another case. That will be enough. And keeping the money. And he collected 700 of that, I believe. But at that point, I was committed to cross-examine Furman.
Let's talk about that, Furman.
I couldn't let OJ down because I'd given him my promise.
Okay, so you're in to get him justice. Cross-examination of Furman, probably your most well-known part of the OJ case. You were tasked with preparing the case, but that's really where you shined in the courtroom. Tell us a little bit about how you prepared for that cross-examination.
I had Furman's testimony in the preliminary hearing to work with. It had more holes than a Swiss cheese. He had broken almost every rule of practice and policy, if in fact he had gone out and found the glove close to OJ's house, as he claimed. Not only that, Bob had not discovered, because he hadn't checked the court records, that Furman had brought suit against the department in order to retire early and get a pension because he was such a bigot. He wasn't fit anymore. Now, this is Furman's affidavit, which Judge Ito kept out. With all those things to work with, I knew he had a fatal flaw, like some of the people I lived with down south when I was in the military. He could not prevent himself from using the word Nigger. All I had to do, I thought, because Furman was the sole link between O.J. Simpson and the murders. They had nothing else of any substance at all. All I had to do to cast doubt on that linkage was to catch him lying. And I knew that they were training him in the grand jury room with a bevy of lawyers not to use that word and not to deny that he used it, because they knew that's right where I would go. And I figured I've got to go at it in such a way that he discovers too late that loose lips sink ships. And the crucial moment as to Furman came when I said, after his denials of using the word within 10 years, and I knew nothing about any tapes then. I did have a dozen witnesses who were ready to destroy him, who didn't know each other. I said, so you deny ever using the word? That means anyone who comes into this court, takes a stand and says they heard you say it, would be a liar. He thought for a minute, he said, yes, they would. I looked at him kind of incredulously, and I said, all of them? And he realized he'd been hammered. There was an army out there waiting to dig him in. And he said, yes, all of them. And he was done. Then, if you talk to the jury, they didn't like him to begin with, but after that, they paid no attention to his testimony. Furman, on the tapes, which we got later, was asked by the gal taping him, don't you think they'll throw you out of the Simpson case now that New York Magazine and the New Yorker have disclosed that you have this suit for bigotry and that you're known to be a really racist pig cop? He said, no, they can't throw me out of the case. This is a case about a glove, and without Furman, there is no glove. Right on tape. So you'll find that in the summary that you described earlier that's on my website. And that was pretty prophetic. How did he know it was a case about a glove? The glove had never been tested for blood, not until late October. The statement was in July. He knew it because he brought it from the scene of the crime and stuck it in OJ's house to keep himself in the case and for that reason alone.
Interesting. Lee, while we're on the glove, we might as well talk about this a bit. You were tasked with preparing the case, like you said. The glove probably is the most memorable part of the case. The glove doesn't fit, you must acquit. You didn't necessarily make that happen in the courtroom, but you planted the seeds by kind of challenging the prosecutors to have O.J. try that glove on. It was your idea. You dared them. They took the bait. Tell us about that.
Chris Darden, who was a good enough fellow, but certainly not very secure, had been called in to sit at the counsel table with Marcia Clark immediately after it turned out the jury was a large majority of people minorities. And Johnny Cochran objected vigorously, called him everything but a token black guy. But Judge Ito said he could sit if he wants. And we became a little bit chummy. Chris would pass me a note every time he did something, argued a motion, stood up and looked around, and the note would suggest that I should give him a grade of A for his performance. And I usually sent back a C minus, and we had this banter going on. So there was a witness on the stand who had been the president of the company that made and sold the Aris light gloves that were found at the scene. And he was putting on quite a show. He didn't really know anything, but he was thrilled to be on national television and doing his best to cooperate with the prosecution. And a recess came, and the right-hand glove, the bloody one found at OJ's allegedly, was sitting on the exhibit table. I hadn't seen it before. I took a look and said, I got a perfect 9 hand. It's going to be tight. OJ's hands are big enough. I mean, makes Gronkowski look small. Big enough to hold a basketball and dribble it without ever letting go. They're huge. I looked at the glove and I said, oh my goodness, we're in Clover. No one's thought to do this. We never even demanded to look at it before. So I leaned over to Darden, and I will quote exactly as I put it in my law book so far, and will put it in the book that I'm now working on. I said, you know, Chris, you're a good shit, but you've got the balls of a stud field mouse. And he jumped up and down. How could you possibly say that about me? That's demeaning. I said, because that glove will never fit Simpson, and if you don't ask him to try it on, I might. Not even my witness. When Judge Ito came back in the courtroom, he was another very short man, but he had a special ladder to get up to his bench. He's up one rung, and sure enough, Darden almost knocked him off the step. He said, Your Honor, I want Simpson to try on the glove. And Cochran, who was stunned, said, in front of the jury? And Darden said, right. Now, he'd been wanting to do this all during the trial, and Marcia Clark said, if you do it, you're fired. So he overpowered the prosecution. The rest is history. The glove was very tight. It wasn't the rubber on the inside. Darden did get fired that night in a temper tantrum up in Garcetti's office, but wisdom being, let's say, emulated sometimes by hindsight, he was hired back the next morning. And it was a fun moment.
Yeah. Well, the glove did not fit.
It was not an agreement between the parties. It's not something I discussed with them beforehand. I saw the glove and jumped.
Oh, wow. They took the bait, Lee. So the glove didn't fit. OJ was acquitted. And to say the least, you're...
Those two, by the way.
What's that?
Don't those two, because the forelady of the jury was so offended by Johnny Cochran's argument, if it doesn't fit, you must acquit. She said to Chief Investigator McKenna, what does he think we are? In nursery school? We could figure that out without him saying it. They were angry.
Wow. Well,
things you don't know. Like
no, that's why we have you, Lee.
Huh?
That's why we have you.
Well, there are little things I don't know, too.
So after the trial, one thing I think that people don't know is that after the OJ trial, You'd invested $400,000 in cost, and you only were paid $15,000. The case nearly bankrupted Johnny Cochran firm. To take on a case of that magnitude, 11 months of trial work, to not get paid and in fact spend a great deal of money, I'm sure the public doesn't understand that type of financial commitment in what would be a high-profile celebrity case. How did that affect you, Lee?
It affected me very adversely. Bear in mind, I got $16,220 total. My expenses were over $400,000. I paid all of those. I never got a fee. So I don't have much motivation to stick up for O.J. Simpson 24 years later.
Very true.
Unless I pretty damn well know what I'm doing.
You've seen O.J. since he's been released from Las Vegas prison, is that right?
I had dinner with him in October.
And how was that?
You know, O.J. is a man of great resilience. His affability after 9 years in prison, for which he never should have been sentenced, was still good. His attitude was good. He was glad to be out. He was happy to be in Las Vegas. He doesn't hold a grudge against the state of Nevada, which I would, big time. So O.J.'s always been able to absorb a lot. That's consistent with the kind of football player he was.
Sure.
O.J. was one of the hardest runners, indeed the first one ever to do 2,000 yards in a season, in the NFL. O.J. had one penalty during his whole career with the Buffalo Bills and the San Francisco 49ers, and that penalty was for jumping on a New England Patriot who had jumped on a Buffalo Bill. Only penalty.
Wow.
If my knees got banged around the way O.J.'s did, I'd had a few elbows and a few noses by that time.
I'm sure that's true. All right, Lee, the last part of our show is what I would call taking the fifth. It's 5 questions I'm going to ask each guest, the same questions. Are you ready?
I think I'm the only guest. You said each guest?
Lee, you're the first guest. You're setting the tone. Actually, I'm going to go off the beat a little bit here. Alan Dershowitz is the second guest. Is there anything you want me to ask Alan Dershowitz?
Yeah, I love him. I always have. He's one of the best lawyers God ever created, and the smartest, I think.
Wow. I'm going to tell him you said so. He's next week, so I'll tell him you said so.
You can certainly do that. Alan and I will write forewords for each other's books.
That's great. So the last part is the 5 questions. The first question is, in your career, what is the single case you're most proud of and why?
2, Dr. Sam Shepard, because I got a guy at the bottom of the barrel, didn't seem to have anywhere to go. Got him out, got him acquitted, and after he died, we were able to show he did not commit the murder with DNA. The other is a case that is anomalous. The worst slaughter ever laid at the feet of the U.S. military was the massacre at My Lai 4 in South Vietnam, actually North Vietnam, I guess it was at the time, when women, children, babies, and elderly were slaughtered in a ditch by American soldiers with machine guns. That was disgusting, would turn your stomach, made it tough to deal with. On the other hand, the military trial that followed and the caliber of my defendant, Captain Ernest Medina, offset that greatly because Medina didn't have anything to do with the slaughter. He got there after it was over, and the military justice system worked flawlessly.
Wow. Very interesting, Lee. All right, the second question, if you could handle a case with one person, dead or alive, who would it be?
What do you mean, handle a case?
I mean
counsel?
prepare and try a case with one other lawyer.
Oh. You know, that's tough because I'm right now starting a school to educate trial lawyers at a higher level, and I'm plucking all of the great guys that I've worked with in the past, and it's a very difficult choice. I think I have to be a little bit persnickety and say, what kind of case? Is this a mob case? Is it a classic Shepard, Coppolino type bizarre murder? that would depend a lot. The guy I always thought was the greatest cross-examiner I ever met has died. And where is he from? Cleveland, of course. But if I had to look around today, the pickings are slim. If you get below age 60. I would have to include in the number Roy Black. Always great to have Alan Dershowitz, although his function is primarily appellate. And there are good criminal defense lawyers scattered around, but they are a dying breed. And if I answer your question with a name, I'll always have to speak up to those I didn't name, so I think I'll take a pass.
Well, you're looking at a 35-year-old that could try a case, Lee, so not all 60-year-olds and under.
No, but I'm talking about people who are nationally known and have won a string of tough cases. That's a dwindling number. Of course, there are criminal lawyers out there, but they don't get treated very well, economically or otherwise.
Right. Okay, question number 3. One book and one movie that has inspired you. Doesn't have to be law-related, just in general.
That's easy. The book, The Art of Advocacy by Lloyd Paul Stryker. It's out there. I would strongly recommend that it be read by everybody who wants to be a trial lawyer, although The Art of Cross-Examination by Francis Wellman is close behind it. Movies, there are 4. Tell your guests, go out and watch them immediately. They are Witness for the Prosecution, a classic British case. QB7, another classic British case about libel of Leon Uris, a true case. To Kill a Mockingbird, classic. And the best one of all, I think, Anatomy of a Murder.
Sure. Lee, the last 2 are fill in the blanks. The first one is a trial lawyer should never do this.
Trial lawyer can be often wrong, but never in doubt.
Very true. Very true. A trial lawyer should do this every day.
Prepare, prepare, prepare. The sea in which you make your living and ply your trade is the ocean, and the part of the iceberg that can't be seen is what wins your cases.
Very good. Lee, you have your wings on. Fighter pilot or trial lawyer?
Both. Got the same blood, and the best trial lawyers tend to be pilots, or as kind of a Merry Christmas to your audience, a jingle that was popular when I was flying jets at 19. There are no fighter pilots down in hell. No, there are no fighter pilots down in hell. Navigators, bombardiers, and a flock of engineers. But there are no fighter pilots down in hell.
Lee, thank you for being our very first guest on the podcast. Thank you very much. You did great.
Merry Christmas.
All right, Lee. Thank you.